I may want to wait a few moments to give some more task force members in particular an opportunity to log.
Center. Teams of two. Okay.
All right, we are currently live, Steve.
Morning. We're going to wait just a few moments to give some more folks an opportunity to sign on here. We'll be starting momentarily. A few moments to give some more folks an opportunity to sign on here. We'll be starting momentarily. A few moments to give. Okay, it's 9:03. I think that is fairly punctual even by today's Zoom standards. And I think we can begin. Good morning, everyone, and thank you for attending. My name is Stephen Flom. I'm a partner in the Chicago firm of Neil Gerber and Eisenberg, and I'm the chair of the Illinois Supreme Court Statutory Court Fee Task Force. We're here this morning, of course, on a Zoom teleconference for the second public hearing that the task force has held. The purpose of this public hearing is for the task force members to receive comments, testimony by interested individuals and organizations and agencies with respect to the draft task force report that we circulated a little bit more than 45 days ago. In terms of where we go from here, the task force will be considering the testimony that we received today, as well as the written comments that were submitted last week, and we appreciate those who took the time to provide the very thoughtful comments that we've received. We're going to give them very careful consideration. I anticipate that we will make some revisions and tweaks to the draft report that you've seen in light of the testimony that we've received. And then ultimately, sometime early this fall, the task force anticipates submitting its report to the Illinois Supreme Court and to the Illinois General Assembly for its consideration. As those on this live stream are aware, and those watching it later undoubtedly as well are aware, that the task force draft recommendations do include some legislative proposals, as well as some proposed revisions to the Illinois Supreme Court rules. Those are submitted for consideration by the individuals and bodies with the authority to act on them. So the format for today then is those who expressed an interest in testifying today have signed up. They're here on a Zoom as opposed to through the live stream. And we're going to, each speaker will have 10 minutes. But I do want to, there will be an opportunity for the task force members to ask questions of the speakers. And, there will be additional time allotted as needed, especially if any questions that might be received. So our first speaker this morning.
George Ortiz to be at home.
Oh, he has COVID.
Okay, are we ready? Is that okay? Judge Ortiz was scheduled to be our first speaker. He's here, right? Yes. There he is. Our first speaker this morning is Judge Jorge Ortiz. Judge, welcome. And if you'd introduce yourself, and thank you for participating.
Thank you, Mr. Flom, and good morning, everyone. I serve in the 19th Judicial Circuit in Lake County, and my current assignment is in juvenile court. And let me just say the views I'm about to express are solely my views, not those of the 19th Judicial Circuit. And so I took an assignment in juvenile court about 2 years ago, and I quickly noticed that the vast majority of the parties in court are represented by the public defender's office. And I also quickly noticed that that there are several fees and assessments routinely imposed on these people, even though they are indigent. And one day I began researching fee and assessment waivers and was surprised to learn that there is no such provision for juvenile court cases. And I believe this is fundamentally unfair, and it unduly burdens indigent youth and their families. And frankly, very little is collected by way of these fees and assessments. And I routinely waive or reduce them in many cases. Courts and counties do not rely upon these fees or assessments to sustain or support operations, and nor should they. And in my view, they should be eliminated at a minimum for indigent parties, if not entirely. These parties should work on rehabilitation without being saddled with onerous fees and costs. So thank you.
Thank you, Judge. Does anyone have any questions for Judge Ortiz?
Yeah, hi.
Representative Slaughter, go ahead. Did you have a question?
Yeah, I'm sorry. Judge Ortiz, thank you so very much for taking some time to be with us this morning. Could you go into a little bit, just a little bit more? You were articulating how, and one of the things I was concerned about was the revenue from the fines and fees being utilized in any way, shape, or form for operations? I believe that you said that they weren't. Is that accurate? And so where does the revenue?
Well, and I'll just speak for my circuit. Very little is collected, frankly. And I wish I had the figures for you, because last year we looked at this because some of our county board members expressed an interest in seeing that these fees are waived. And very little is actually collected. So you might have the detention fees, you've got all these other fees, public defender fees being assessed when these folks are indigent to begin with, being represented by the public defender. So very little by way of these fees or assessments is collected. And frankly, these fees shouldn't be relied upon to sustain the operations. Now, I understand that there's certainly many costs attendant to running a juvenile detention center or running juvenile court in general. But, again, we're talking about the vast majority of these people being indigent. And so we're setting them up for failure if you're going to be ultimately entering judgments against them or their parents who are indigent. And instead of having them concentrate on rehabilitation, on improving themselves. But what we see is a lot of these folks are saddled with these judgments ultimately, which in some jurisdictions, I understand that collection efforts begin against these folks. So I'm sorry I can't answer your question specifically. And I know that, you're being a legislator, you have to address ways to fund these types of operations. But again, frankly, if we're about rehabilitating these minors and providing them a fresh start in life, we should not be saddling them with these fees, especially if they are indigent.
Yeah, Judge Ortiz, you answered the question quite well. Again, thank you for your service and for being on with us this morning. Thank you.
Thank you very much.
Do any other task force members have any questions for Judge Ortiz? I do have one, Judge. The task force's draft report does recommend that legislation be enacted abolishing assessments and fees in juvenile delinquency cases. but preserving juveniles' liability for restitution in particular. And the task force recommends that the general, at least in the draft report, recommended that the General Assembly pass legislation in the form of a pending bill known as Senate Bill 3621. Do you know the extent to which that bill is consistent with your with the views that you just expressed? Or do you join in that support, or perhaps you're not familiar with that bill?
No, I did review the bill, and it is pretty consistent with my views. With respect to restitution, obviously victims need to be made whole, and sometimes the orders for restitution are quite significant. However, the court must make an assessment as to whether or not that particular minor or family has the present ability to pay the restitution. So I think in terms of victims, I think that perhaps there should still be a provision to allow for restitution to be ordered.
Okay. Thank you, Judge.
Thank you, Mr. Flom.
Hearing no other questions for Judge Ortiz, our next speaker is Angelica Jimenez from the National Center for Youth Law. Ms. Jimenez, I want to thank you for both for your testimony today and also for the written comments that were submitted by the National Center. So the floor is yours. Whoops, you're on mute.
Thank you for letting me know. Good morning, Chairman Flom. Thank you so much for the opportunity to speak today. My name is Angelica Jimenez, and I'm a senior attorney with the National Center for Youth Law, and I'm also an Illinois native. We strongly support the task force recommendation to abolish fines and fees in juvenile court in the form of Senate Bill 3621. And we want to bring attention to egregious practices that our youth are subjected to when charged with municipal ordinance violations. We urge the task force to consider the harms administrative adjudications cause and advocate for the abolition of fines and fees in this system. First, ProPublica's recent investigations identified a disturbing pattern of ticketing students for school-based offenses. Students were cited for conduct as minor as littering, making loud noises, or using offensive words. Horrifyingly, reporters found that over 11,800 tickets were issued over the course of 3 school years to children as young as 8. Significant racial disparities were also found, with nearly 20% of tickets being given to Black students who comprise only 9% of the student population. Youth are forced to navigate quasi-judicial proceedings, commonly held at police stations and village halls, before lawyers and not judges, without the right to counsel. They often plead guilty in order to pay, with significant variation across municipalities. Most youth had already been punished by their schools, some even expelled, and now forced to pay hefty fines and fees. Second, these assessments undermine and directly contradict youth rehabilitation. Youth unable to pay aren't learning a lesson. They face severe stress that destroys their trust and the fairness of the system, which can negatively impact compliance. These youth are forced to financially rely on their families, if their families can help, or find a way to pay themselves, deprioritizing their education. In contrast, youth whose families can afford to pay learn there's no meaningful consequence. As a result, the task force has found holding families jointly liable can harm the families at a time of significant importance. Third, this practice fails to consider their developmental needs by punishing youth in the same manner as adults. The task force cites DOJ recommendations for special practices to youth's best interest. Administrative adjudications routinely assess fees and fines without consideration of ability to pay. Fourth, municipal fines are most frequently assessed against low-income families and youth of color. The task force found that youth of color are more likely to be arrested and detained than their white peers. This is the same for administrative adjudications. Low-income families may be forced to choose between paying these assessments or paying necessities. No family should be forced to make that choice. Multiple families we spoke with had no idea how they would pay the fees and fines, even if they were given more time to pay. If youth are unable to pay, they might face additional costs, continued court oversight, and possible contempt charges. These youth end up paying even more in the end, with devastating consequences to their future opportunities. Finally, ending assessments would benefit municipalities. A funding structure that is heavily reliant upon revenues from assessments of low-income families is unsustainable. In fact, it is likely that counties would actually experience cost savings if they eliminate these fees imposed on youth. While it appears like the counties don't collect and don't use collection agencies for juvenile court assessments and administrative adjudications, they do. Now, states that have eliminated fees and fines in juvenile court have found that these revenue-raising tools were actually cost prohibitive. Thus, abolishing fines and fees is the best course of action for everyone involved. In conclusion, we applaud the task force for your work to improve our courts by addressing the unjust barriers that fines and fees create. Thank you.
Thank you, Ms. Jimenez. Any questions from task force members?
Yes, I have a question.
Judge Biello, go ahead.
Do you happen to know whether this using ordinance violations against children in school, whether that is something that is new or just newly discovered?
I believe it's newly discovered. Senate Bill 100 that was enacted a few years ago really aimed to eliminate that practice in schools by prohibiting the schools themselves from issuing these fines and fees, issuing tickets on students. However, what they're seeing in practice after the enactment of this law is that they are working with police officers, and the police officers are doing that. So they're not violating the law. However, they're fine. There's another way to do it. So it's more recent in terms of how it's being administered. And the Senate bill also really focused on coming up with alternatives and really focusing on the students' needs. So we're seeing that this trend moving forward towards reform, we're seeing some steps backwards.
Thank you.
Thank you.
Any other questions? Ms. Jimenez, do you have any, is there draft legislation that's been suggested that would implement the measure that you are advocating for?
We've been working with our partners on Senate Bill 3621. So we've been working with the entire coalition, the Debt-Free Justice Coalition of Illinois. And so in our conversations, as we said, we strongly support the bill. And if it is possible to include that specifically, and we understand that restitution is not part of that, but if municipal ordinance violations could be, really because we believe it goes to the essence of the bill and what the bill is aimed to address, that would be the way. So that we are committed to working with our partners, and we've been in communication with them to have that as a possible provision to the bill once it gets reintroduced in the next legislative session.
Is there draft legislative language that's been
We've
prepared?
started, yes, I'm sorry. We have started working on draft legislative language. We just need to pass that on for review.
Thank you.
Thank you.
Any other questions for Ms. Jimenez? Thank you for appearing and for your testimony.
Thank you.
Our next speaker is Pastor Norma Patterson from the Debt-Free Justice Illinois Coalition. Again, I want to thank the coalition for its written comments, which the task force is considering as well. And Pastor Patterson, we appreciate you coming today to testify. Good morning. The floor is yours.
Good morning, everyone. I'm Pastor Norma Patterson, and I'm a member of this task force. I'm a pastor in East St. Louis, Good Shepherd of Faith United Church of Christ. And I'm also a retired teacher from teaching in St. Louis public schools for 25 years, 16 years as a teacher in the classroom, 9 years as an administrator. And so I've seen children in middle school and in high school targeted because of that pipeline that extends from school to prison. People say it's not there, that it's invisible, but I'm here to tell you that it's real, it's documented on a regular basis, and certain children are targeted. As a result of my experience in the school district and my experience as a pastor in East St. Louis with church members suffering from these fees and fines because their children are targeted, and they are responsible for those kids. And sometimes they are not the parents. Sometimes they are the grandparents. Our community organizers have been at the forefront of this coalition campaign to end juvenile fees and fines by connecting with impacted youth and families in Illinois. On behalf of our community organizers, I provide my testimony and full support of the task force findings and recommendations under new Initiative 3 regarding assessment and fines in juvenile delinquency cases. The Gamaliel Network, and I'm a president of Gamaliel, Illinois, is a faith-based, multi-ethnic, multiracial, grassroots organization whose mission is to train ordinary people, primarily low-income people from communities of color, to effectively participate in the political environment. Their social, economic decisions that affect their lives oftentimes are overlooked because the people don't know what to look for. If they're not invited to participate in their lives and what happens to them, then we don't even know what's going on in the communities. Most people don't know. We are a part of Central Southern Illinois and mostly the Metro East community. These are the counties that we're connected with. These youth and their families that are affected by the juvenile justice system are in Cass County, Morgan County, Sangamon County, Macon County, Madison County, St. Clair County, Monroe County, Randolph County, Jackson County, and Franklin County. Sometimes because we're in the lower part of the state of Illinois, we are totally ignored. But we are on board with the bill that we want to push. We want this bill passed because our children are suffering at a higher rate than most children in other counties. Our community organizers have been working on the campaign to eliminate juvenile fees and fines, advancing Senate Bill 3621 since November of 2021. Over the course of 4 months last spring, we interviewed about 50 impacted youth through one-on-one meetings in the counties mentioned earlier. We want to uplift the following youth stories, which exemplify the harms and long-term consequences that the youth and their parents face as a result of fees and fines imposed upon them. The youth wish to remain anonymous, so the names of the youth or these anecdotes have been changed to preserve their anonymity. Jay, who is now 17-year-old, has been involved in the county's juvenile system for several years. His first contact with juvenile justice system was at the age of 13, and he was fined for the incident. His parents had to pay the fine off, and it was a huge strain on his family. Jay informed that his parents couldn't sleep from the financial burden. There are 27 housing projects in the city of East St. Louis. No other city in the state of Illinois with a population of 27,000 has 27 housing projects. Who has that in their community? And so the children are lumped together. They go to school together. They go to the park together. They don't have any outside connections other than each other. What laws, what government allows that to happen? I've been to other states and I don't know anywhere where I've seen that happen. Dennis is now 16 years old, but was involved in a traffic accident when he was 15 years old. He was arrested in a county, one of the ones that I named, after the accident for not having a license. He received a $1,700 fine, which he and his family are still paying off in monthly installments. A year later, and they still haven't paid it off. Does that sound familiar? People who went to college paying student loans, 40 years, 20 years, and still haven't paid them off. Dennis can't obtain a license because of this incident. He has to work in order to pay off the fine, and not being able to obtain a license has added chronic stress on his commute, his needs for work, and his school commitments. The majority of the youth in the Illinois juvenile system are low-income youth of color, which means that the youth and families of color bear a disproportionate burden in the assessment of juvenile fees and fines across Illinois. Through the interviews we conducted, we learned that grandparents also bear the financial burdens of assessments, since they're often the only caregivers for many children and teenagers across Illinois. Juvenile assessments can amount to over thousands of dollars, and even with monthly payment plans, these financial burdens create a significant long-term financial and social challenges for impacted youth and families. Low-income families of color end up paying much more for the exact same offenses and charges in juvenile court than their Caucasian counterparts and more privileged counterparts pay. It is time to end such unjust and unequitable practices in the state of Illinois, because fees and fines only hurt youth and families. For all these reasons, we strongly support the task force recommendation to abolish assessments and fines in juvenile delinquency cases by enacting legislation substantially in the form of SB Senate Bill 3621. I'm a preacher, you guys, so I can't just read it. I have to testify and preach to you a little bit. Okay, thank you.
Thank you, Pastor Patterson. We appreciate that. Anyone have any questions? Hearing none, again, thank you very much for your testimony.
Okay.
Our next speaker this morning is retired Judge George Timberlake. Judge Timberlake? You're on mute. Something we've all experienced during the age of Zoom. There we go.
Oh, thank you. Thanks a lot. Thank you for the sermon, Ms. Patterson. That's exactly the kind of story that needs to be told throughout the state of Illinois. And I'm from Southern Illinois. I've been retired for a long time, but this subject is one that I have examined in many ways. As chief judge, how to manage review hearings, deal with the other members of the court system to collect these fines. And because of that experience, both as a chief, but much more so, I spent 15 years as an associate judge. And during that time, this is the call I got to do a lot. So tell me, if we spend an entire court day having people show up because they owe fines, fees, costs, and restitution, what do those resources cost? More so, let's talk about what could be important financially in the justice system, and that is restitution. Here's a situation that I often encountered, and one of those being personal. I've been in the real estate business investment for a long, long time. A young man, high on meth, burned down one of my garages. So I'm insured, but you got a $500 deductible. So the fine, rather the sentence for this young man included fines, fees, costs, and restitution. The state's attorney is a friend of mine and a person I respect. After or towards the end of the young man's probation period, they dismissed the case. Fines, fees, and costs were paid. Restitution was not. So the financial part of the justice system ought to be to make people whole if they've had a real loss. Now, that varies all over the place, but the question really is, how much money are we spending in court resources to recover how much money that is likely never to be paid, just as Reverend Patterson has said. That happens in the adult court, of course, and sometimes for good reason. For juveniles, I suggest this is nuts. What we're trying to do in the justice system is repair the harm that a child has caused to another. Restitution may well be the only thing that should be ordered in terms of fines, fees, and costs. But let's go farther than that. The court resources, the time for defendants, the time for attorneys, the time for judges, clerks, bailiffs, and all of that. Judge that against the harm caused to an individual who's been ordered to pay restitution and doesn't get it, either because someone refuses or because someone simply doesn't have the education and job skills to be able to go forward. We ought to be concentrating on that sort of stuff. If we're going to stop crime, then you have to intervene in people's lives in a way that's meaningful to them. Restitution can do that. Several of you have heard my speeches about restorative justice. This is the point right here where we can consider that restorative justice is not a replacement for, but the forum in which restitution is determined, not by us, not by the system, rather by that person or company or whomever has been harmed has the opportunity to say, okay, I want you to pay me $1,000. Kid says, I don't have $1,000. You know, I work after school and make $30 a week. Instead, restorative justice gives the opportunity for that person who has been victimized, who's been harmed, to speak directly to the person who caused that harm, and then work out their individual arrangements as to, what are you going to do for me? I've been harmed. I want you to hear it. And if you're sincere, here's what you could do to help me. Doesn't mean write a check. Doesn't mean that we got to see each other every Friday for the next 10 years of our lives because you owed money. Instead, let's get to a point where justice is served at a local level, on a personal level, not on a system level, because the system hasn't done a very good job of carrying this through. If you survey the amount of monies owed to circuit clerks throughout the state of Illinois, it will boggle your mind. The opportunity to recover that entire amount is infinitesimal. The amount that you're going to write off because finally somebody dies, because the judge realizes it's never going to be paid because the guy isn't capable. Let's go to the justice involved in this. And what's just been said today, what's being considered by the court, what's being considered in the legislature is just that. Let's make victims whole. Let's help offenders progress beyond whatever behavior or life condition created it. That's justice. I thought that's what the system was about. And I think that's what we strive to do every day. Thanks.
Thank you, Judge Timberlake. Do any task force members have any questions for the judge? Okay. Again, thank you very much for your testimony.
Thank you.
Very thoughtful. Our next speaker is former Representative Steve Anderson, a member of the, is he here?
I am here.
Great. Great. Good to see you, Representative.
Thank you. Thank you.
Member of the original Statutory Court Fee Task Force. Welcome.
Thank you very much. As you said, my name is Steve Anderson. For the record, I've been a licensed attorney for 30 years, about the first 20 of which I was also a local prosecutor. So I spent a great deal of my time, at least once a week, in our local traffic courts in Kane County, actually doing a lot of the work that we're talking about here today, including suspending a lot of people's driver's licenses for not showing up, entering ex parte judgments for people not showing up, and creating part of the problem that I think we're here to address. I really want to compliment Judge Timberlake's commentary about the inability to collect on a lot of these imposed fees. That is the literal truth. As you mentioned, I'm a member of the original task force, and it was a pleasure to serve with several of you who are on the current task force, and I was the sponsor of the CTAA in short. So this is a area that is near and dear to my heart, and I want to thank the members of the task force for your hard work on this. When I had the opportunity to review your draft report, I really was impressed. You've taken what we started with and really launched it to the next level. So my compliments to you on what I see as an excellent first draft and an excellent debate about where we go in the future. So thank you very much for that. I also am speaking specifically, though, as a lobbyist for the Chicago Jobs Council. The Chicago Jobs Council's mission surrounds removing impediments to work opportunities. And in this case, specifically, we're dealing with the issue of driver's license suspensions and how that affects people's lives in general. We also comprise a transit table, which is comprised of actually many of the organizations that you're hearing from today or who have received testimony to advocate for this issue. Specifically, what we're dealing with is to outline our position on the harms of fees to the lowest income people, specifically fees resulting from a failure to appear in traffic court. At present, over 100,000 people in Illinois have suspended licenses for failure to appear in traffic court. These suspensions often are just an extension of the traffic ticket debt collection process. This is because even though a driver's license suspension is initially imposed after a person's failure to appear in traffic court, many circumstances, many court clerk systems thereafter also enter the ex parte judgment, and then the Secretary of State cannot reinstate the license until the ticket is paid, and they go back to court to seek reinstatement. As a result, in many places, failure to appear suspensions become failure to pay suspensions in real practice. Like other debt-driven suspensions, the real-world impact of a failure to appear suspension devastates communities of color. According to our research data, the top 10 zip codes in the Chicagoland region with the most failure to appear suspensions have predominantly Black and Latino residents. 9 of those zip codes have a majority of Black residents, and one of them has a majority of Latino residents, all with above average poverty levels. Minority workers are hit the hardest. Only 16.2% of Latino and 19.7% of Black workers can work from home, compared to 30% of white workers. This means workers needing driver's licenses are the most likely to have licenses suspended for failure to appear. In many states, fines and fees to fund law enforcement distort police priorities and ultimately impede public safety. In cities where police departments receive more funding from fees, police solve violent crimes at a significantly lower rate. You heard that correct. According to our research, a 1% increase in debt-based revenues, money from fines, fees, and forfeitures, was associated with a 3.7% decrease in violent crime clearance rates. In other words, or perhaps more simply put, the focus of law enforcement shifts from what their main purpose would be, which would be to clear those violent crime rates, instead to collections. Fines and fees that often underline a failure to appear driver's license suspension put minority workers in really an impossible situation. They either choose to drive illegally because they have inadvertently missed a traffic court appearance date, or they lose their employment and subsequently their ability to live. It really becomes a spiral downward, if you will. In fact, if they take that risk and they drive while suspended, oftentimes that means they're now receiving another ticket for driving while license suspended, which is more serious and more significant. So you'll see a spiral downwards amongst people because they make an impossible choice. The choice either to work or not work based on one incidental failure to appear. We believe those failures to appear, by the way, are at the root of the system, which is that it's complicated and it's difficult for people who are not familiar with the court system to always make their court dates or to understand exactly when and where they are. Among our survey respondents served by workforce development and adult education programs across the state, 25% have experienced a suspended or revoked license. On the one hand, our government services are trying to help get people employed. There's no doubt about that. But on the exact opposite hand, we're using the Secretary of State's office to hold them back unnecessarily. Suspending driver's licenses for failure to appear does not promote public safety or help collect unpaid fines and fees for traffic violations. Suspensions hurt people's ability to earn a living and find housing, which is bad for the business community and ultimately bad for the entire governmental system. Failure to appear in court for driver's license suspensions for fines and fees should not dictate a person's ability to work, provide for themselves and their family, and live. We believe state legislative and court reforms can restore integrity to the criminal justice system and align fees and fines with the system's broader goals. Reforms are urgently needed to protect low-income families from being trapped in ruinous debt and people from being penalized, sometimes incarcerated, simply because they can't pay court fines and fees. Specifically to your report, our comments here today are directed at your new initiative number 4, which is debt collection. We would ask you specifically to consider adopting House Bill 5588. That's House Bill 5588. Representative Nick Smith is the sponsor into your recommendations. It eliminates suspensions for failure to appear in court. While this is not specifically a fee, it will result in the reduction of the fees needed to reinstate driver's licenses at a later point. And as I indicated, if our system is designed to allow people to address their justice system issues and still allow them to work, we are in a much better place. Also, remember, the only remedy for a failure to appear is not a driver's license suspension. Sometimes when the police stop an individual, they will give them what amounts to a personal recognizance where they do not ask for anything, or they'll post a statutory cash bond for that same issue. In neither of those cases, so 2 out of 3 cases, those people will not receive a driver's license suspension. But only in one case, where someone posts their driver's license, will they suffer this significant penalty. So we're asking that things be aligned more to what I would characterize as the more common collection method. Finally, and this is a separate item and a personal item, so I'm now not speaking for the Chicago Jobs Council, speaking only for myself as the sponsor, is I would ask that you, as you indicate in your report, advocate for the repeal of the sunset. When we created the original CTAA, that was my solution to getting a lot of different organizations on board. There was a great deal of anxiety over how much of a change we were making and whether we might have miscalculated the impact of the various changes in fees. And so my suggestion honestly was, let's create a sunset. We did, that got the bill passed. But what we've seen and what you've seen since then is that it has not dramatically impacted either positively or negatively the variety of different agencies. So with that being the case, the reason for the sunset no longer exists. So I fully support your recommendation in that and ask that as this moves forward, that remain there and that we remove that sunset. This is not something that needs a sunset any further. And with that, I thank you for the opportunity to speak. And of course, I'm happy to answer any questions.
Thank you, Representative. Does anyone have any questions for Representative Anderson?
Yeah, Mr. Chair.
Oh, go ahead. Yes.
Representative Anderson, retired. Thank you so very much for being with us this morning. I also want to just thank you, and we're so grateful for the time and energy and effort that you put into this subject matter. Often throughout your testimony, you are referring to some data and reports and statistics. Can you just make sure that the task force has what you were reading from and referencing? And I think it's very, very valuable, obviously, to be able to lean on the data in the stats. So I know all the members appreciate that approach as well. So thank you, Steve.
It's my pleasure. We do have that all, and we will submit it. Thank you very much for that opportunity.
Thank you. No, we welcome that, and that could be submitted online. Thank you, Representative Slaughter, for that suggestion. Any other questions for Representative Anderson? Okay, again, thank you. Our next speaker this morning is Brian Gaughan from an organization known as LEAP. Mr. Gaughan?
Good morning. Thanks for allowing me to speak to you folks today. Greetings, Chair Stephen Flom and members of the Statutory Court Fee Task Force. I speak here today in favor of the proposed Initiative 3 because I believe that ending fines and fees for minors would strengthen police community trust and lower recidivism amongst minors. My name is Brian Gaughan, and I'm weighing in on this issue as a retired Illinois law enforcement officer and as a speaker for Law Enforcement Action Partnership, also known as LEAP. LEAP is a nonprofit group of police officers, prosecutors, judges, and other criminal justice professionals who speak of our experience from within the criminal justice system. Our mission is to make communities safer by advocating for the focus of law enforcement resources to be placed on the greatest threats to public safety and working towards healing police-community relations. As a police officer, I saw firsthand that our young people needed support and positive interactions from officers in the community, not financial penalties. Every effort to positively engage with young people served to keep them out of the criminal justice system, which improved community trust. Unfortunately, when youth get into trouble, they face financial consequences. Juvenile fees and fines, the costs and monetary sanctions that are imposed on youths and their families for the youth's involvement in the juvenile delinquency system, actually operate as a regressive tax on the Illinois families who can very least afford it. These youths and their families are charged a range of fees, including for detention, probation, supervision, and electronic monitoring. These juvenile fines and fees are counterproductive, actually. They come with harsh penalties and other negative consequences for non-payment. They fill our courtrooms with families who are there solely because they are unable to pay the fines. The fact is, these don't generate net revenue because most families with children in the justice system are low income. As the Statutory Court Fees report points out, often there's little attempt even made to collect those fees. And since we realize that's the case, what we should do is do away with those harsh juvenile fees that keep children engaged with the criminal justice system, which studies have shown does lead to recidivism. And lastly, these fines and fees, they in no way deter crime. And in fact, they increase it. And they do that by pushing families further into poverty and forcing them to make decisions between paying rent and feeding their family or paying fines and fees. which in turn leads to continued interactions with the justice system. Implementing this initiative would eliminate fines and fees imposed under the Juvenile Court Act of 1987. States from every region of the country are taking similar action to eliminate juvenile fees and fines. In just this past year alone, Louisiana, Virginia, Colorado, New Mexico, Texas, and New Hampshire eliminated juvenile fees and fines, following in the footsteps of California, Nevada, Maryland, and several other states. Illinois now has the opportunity to join those states in a very much common sense bipartisan reform approach that will help Illinois youth and families. I believe that this initiative will also help improve police community trust, which is so key to what's going on in this country. The police are only as strong as our relationship with the public, because they prevent and solve crimes, big and small, based in large part on the information from victims and witnesses. Victims won't report crime if they don't believe in the system. A recent report actually found out that more than half, it's mind-blowing to me, that more than a half of all violent crimes went unreported between 2006 and 2010 in this country. When people see that their family is weighed down by juvenile justice debt, who do they blame? They blame the figure that they see, and that's the police. They blame the police. And when they blame the police, they're not going to talk to the police. And when they don't speak to us, crimes don't get reported, witnesses don't come forward, and as a result, all residents suffer. I urge you to join me in supporting this initiative to protect struggling families and improve police community trust, which will result in a better Illinois for all of us. Thanks much for the opportunity to share my experience in support of this bill. Be well.
Thank you, Mr. Gahn. Does anyone have any questions for Mr. Gahn? Okay. And thank you very much for very helpful testimony.
Thank you.
Our next speaker, I believe, will be Deputy Public Defender Paul Roe Taylor from the Cook County Public Defender's Office. Ms. Roe Taylor, welcome.
Thank you. Thank you. I appreciate the opportunity to provide comment to the task force regarding the draft report today. As you said, my name is Paul Roe Taylor, and I am a Deputy Public Defender with the Law Office of the Cook County Public Defender. The office has and remains strongly in support of all efforts to reduce the impact of court assessments for our clients. And we're pleased that the task force is taking up and proposing solutions to implement challenges to the Criminal and Traffic Assessment Act. I'm here today to comment on the implementation proposals, as well as to commend the task force for the excellent work that you've done so far and speak in favor of our recommendations and the new initiatives detailed in the draft report, and highlight a few areas where our office believed that the recommendations could go further to address the additional issues. We are in agreement that removal of the sunset on and to continue to document the impact of the Criminal and Traffic Assessment Act. We believe, as stated earlier by the representative, that there is no longer a need for that, and that it is our position that the collection of the additional information will assist in evaluating the impact of the act. And that is one of the things that we have all learned, that it is that data that helps guide the decisions that we make. And that would be incredibly helpful for us to have. Moving forward, it remains essential that we're able to better understand the assessments of people who are accused and how to balance the county budgets in order for us to continue to do the work that we have for each of the court's systems. We're also of the opinion that we need to close the loopholes that defeat the goals of the Criminal and Traffic Assessment Act. I've been a lawyer for more than 30 years. I have handled numerous matters in the court system. And it is always heart-wrenching when part of the negotiations is how a client is going to pay the fees and the costs associated, whether some are mandatory or whether some are actually part of the state's offer or prosecutor's offer. For a client who stands before us indigent, where the assessment has already been made by the court that they are indigent, and now as part of whatever sentence, they are responsible for, they now have this financial burden. Those types of instances are a workaround for the act, and we have to make sure that those are prohibited moving forward. And so we commend the task force on considering how to get rid of those instances where people are not given an opportunity just to pay the restitution and avoid court fines and fees. Another oppressive portion that we have to consider are the late fees. And there was, I believe the representative also talked about the piling on and what that means, not just for the traffic, but also for clients who lose their jobs because they were taken into custody. They fall behind because of their inability to get back to court, sometimes to get to work because just of financial burdens that they have. And the piling on of these costs and these fees further digs a hole for them that becomes impossible to get out of. And yes, sometimes they reoffend. A lot of times they are trying to balance their family's needs versus their own. So we also echo the testimony that came regarding the juvenile cost and fees as it relates to not just those minors, but of course their families. So many children are unable to get the paper route that used to be available, or to cut grass, or to do those things where they could save some money. They live in urban areas where they may just not have access to those weekend or those jobs. And certainly considering that there is harm that is there, working out restitution, we need to be creative. We always need to be creative in how to make a victim or complaining witness whole. But we have to challenge our imaginations of how to do this. I've seen some very creative instances where, and I believe someone made the reference to restorative justice court, as well as sitting down with a complaining witness and asking them, what can we do in situations where there isn't great bodily harm or other instances to make sure that this juvenile will be rehabilitated and will contribute to what harm you suffered. So I think that we can do that. So we do echo the positions that have been taken regarding juveniles who find themselves burdened with these costs and assessments. I would also like to address some of the other issues that we have with our clients who are re-entering the system, who are sentenced to the Illinois Department of Corrections, who are also saddled with fees and costs when they return. I think mostly everyone on this task force can appreciate the difficulty that clients have in re-entry. Every program won't take them. Every employer will not consider them. Some of those clients, a lot of those clients have difficulty getting jobs. Getting back into the workforce is one of the main ways to even be able to support themselves. And oftentimes, because of the felony convictions, they are looking at fines that they're responsible for. And they're looking for ways to pay that and to take care of themselves. It's an undue burden. They have just been penalized in a system that sought to rehabilitate them. But the reality of that is that they are unable to pay. They are unable to find jobs with livable wages such that they can pay off the thousands of dollars that have been assessed against them. And it is shocking to see as you sit in court, and as I have, when you just hear the judges and the prosecutors say, well, the agreement is $10,000 that's being assessed, or $25,000, knowing that that client becomes more unemployable the longer they stay in prison. And then when they are released, somehow there's this expectation that they begin to pay. And often I have sat through hearings where there have been findings that the person is unwilling to pay because they did not get a job, even if they can show the law that they went to several different places. So we commend you on the consideration that those not be part of agreements by the prosecution and the defense in plea agreements. I also want to raise just one other major issue for us, and that is the cost that is actually legislated on the books regarding the reimbursement of the public defender's office. And while it is not imposed, it is still in existence. And this is very contrary to the court who has made the assessment and the finding that the person is indigent. And in a felony case, they could be responsible for up to $5,000 of our services. When there's a finding, absent some later showing that this person has the ability to pay, it is very inconsistent with the court's original finding of indigence for the purpose of appointing the lawyer from our office. Because of this inconsistency and no showing that this person has any ability after the case is complete, it is just another layer of a burden placed upon our clients. Most of our revenue comes from other agencies, right, and the state. And a lot of our clients are taxpayers. Their money is being spent even for the prosecution of their own cases. But then to try to tack it on at the very end, after that matter is complete, if they are not successful, is almost like a double tax for them to now have to pay back into the system for the use of a system that they were seeking justice in. So we commend you for the consideration of eliminating, and we would ask the task force to propose eliminating that particular section of the legislation, as our clients are being, again, unduly burdened with the cost of our services when they've already been found to be entitled to our services. So I would like to thank you for the opportunity to be heard today and for all of your work as proposed in the draft report. Thank you.
Thank you, Ms. Roe Taylor. Does anyone have any questions? Parag Bhadwani, go ahead.
Ms. Roe Taylor, thank you for your testimony today and for the public defender's written comments as well. One just question of clarification on the reimbursement legislation. I believe I caught you said that it's not imposed. Is that just a policy in Cook County, or are you aware of some statewide policy regarding the lack of enactment of that or enforcement of that legislation?
So Cook has imposed that provision from time to time, not currently, but it has happened under a previous public defender. It is a very difficult position to be in, certainly is not a position, even when it was happening, that we were making that proposal to our clients or advising them. It was actually that the state was telling, or the judge was telling our client that they would be seeking reimbursement, and that notice had to be given at the time that we were resolving the case. Was it happening in other jurisdictions? I don't have the data on that, but I know that as long as that piece of legislation sits there, it can be imposed. So while it is currently not a practice, I have no reason to think that it will not rear its head again and be pushed as a revenue stream to come from our office, because we're the ones that are the least likely to be able to have a revenue stream coming from the services that we provide to indigent clients.
Thank you.
Any other questions?
Yeah, I wanted to follow up on that. I think this is imposed in other counties. In fact, it's imposed in my county. And I know it's not in Cook County right now, but from your testimony, it sounds like you've been there quite some time. So you may have some information about when it was. So my question to you is, if you know, when it was being imposed, how often was this assessed against defendants? Whether those assessments were paid, and if they were paid, where did the money come from? In other words, was it assessed and taken out of maybe bond that the person had put up, or was there some proceedings after the case was over to collect it? And finally, it doesn't sound like the public defender's office relied on this as a revenue stream. So I'm guessing, but you can correct me if I'm wrong, that not having the ability for this to be assessed is not going to hamper the ability of the public defender to do their job.
So I'll try to take that in parts. Please remind me if I miss any of those questions. So I can tell you that the imposition of the payment was not as often, because, as you can imagine, some judges recognize that the additional burden placed on the person before them would be just buried in debt. So often, and there were some fundamental objections that were being made, and judges would often say, I'm not going to assess, even though I can, I'm not going to do it because this is a misdemeanor case. It's $500. There's no way that you'll be able to pay that in addition to all the other things. So even where the request was made by the prosecutor, judges would actually go on the record and say, I'm not going to impose that at this time. I've never seen a full collection, though there was an order often that it be paid if that client had posted bond. And the schedule was never very clear, but a portion of it was paid. And then they were told, you need to pay that amount. And, the clerk's office would be the designated place for it to go into the bucket and to be spread about. And it's not even that our office was getting it in total. And oftentimes it had to be written in on a lot of orders because it was not standard. I think you also asked about, I'm sorry, if you can remind me, Mr. Fiallo.
The only other thing that I mentioned, I think you've covered all the points that I asked, which are they weren't assessed often. If they were paid, they were paid out of the bond money normally, and there wasn't, at least you didn't experience any sort of post case collection efforts.
No, we did not. There was so much confusion when it did happen. There were some clients who actually sent checks to our office. We had to certainly get those right over to the clerk's office so that those could, be given against whatever the debt was. But no, there was no huge influx that affected our budget, such that we could hire more people or that we could, get more resources. And then it went away. So we have enjoyed the fact that that no longer is a practice, but we do live in fear that it could rear its head again. And I feel very bad for you that it is in your jurisdiction, because it is such an inconsistent message to the person who's being appointed a lawyer for our office. And then once they get their case resolved, they're being told, oh yeah, by the way, that free lawyer isn't really free. You're going to have to pay a portion of their salary for their services. It is unfortunate.
Thank you.
Thank you.
Does anyone have any questions? Again, thank you, Ms. Roe Taylor, both for your testimony today and also for the very careful comments that you and your office submitted, the written comments, which were also very valuable. Thank you for that.
Thank you.
Our next speaker this morning is Amy Galvin. Ms. Galvin, I have you identified as with the ISBA, although I realize you're, I believe, with an organization called Stand for Children. So welcome, and the floor is yours.
Thank you so much. And yes, I am with Stand for Children, and I'm speaking on behalf of Stand and the Debt-Free Justice Illinois Coalition. So thank you, Chair Flom and members of the Statutory Court Fee Task Force for holding this hearing to gather public comments on the task force draft report. As I said, my name is Amy Galvin, and I'm the Government Affairs Director with Stand for Children Illinois. Stand for Children Illinois is a nonprofit that advocates for educational equity and racial justice to create a better future for us all. As a member of the Debt-Free Justice Illinois Coalition, STAND is committed to eliminating harmful, and economically unjust fees and fines imposed on youth and their families in the juvenile justice system. Juvenile court fees and fines undermine youth success by perpetuating cycles of debt and can prolong a child's involvement with the justice system, further delaying plans like college and career. And I think we've heard a lot of testimony, to that effect today. Stand for Children Illinois and the Debt-Free Justice Illinois Coalition strongly support the task force's findings and recommendations under new Initiative 3 that calls for legislation abolishing assessments and fines in juvenile delinquency cases. Debt-Free Justice Illinois is part of a national movement that has brought together organizations from across the political spectrum to end the harmful practice of juvenile fines and fees. Since 2015, 20 states have reduced or eliminated juvenile fines and fees, and it's time for Illinois to do the same. Debt-Free Justice Illinois is proudly bipartisan and enjoys support from groups that stand on both sides of the political line and spectrum, as well as support from a wide variety of stakeholders, including judges, state's attorneys, probation officials, youth correction officers, and law enforcement leaders that have joined us in our call to end juvenile fines and fees. Thank you to the task force for recommending that the General Assembly pass legislation substantively in the form of SB 3621, which, as we've covered today, will eliminate all juvenile fines and fees in delinquency cases. This bill will take Illinois one step closer to achieving a more just and rehabilitative system for young people in our state. We strongly support the task force's recommendation and encourage the General Assembly to enact that legislation in the form of SB 3621. So thank you so much.
Thank you, Ms. Galvin, and thank you also for the written comments that were submitted on behalf of the coalition. Does anyone have any questions for Ms. Galvin? Okay, thanks again for being here this morning. Our last scheduled speaker is CJ Beck from the Chicago Appleseed Center. Good morning, Mr. Beck.
Good morning. Thank you very much. So hello, my name is CJ Beck, and I'm here today on behalf of Chicago Appleseed Center for Fair Courts. Chicago Appleseed is a nonprofit that seeks equitable and fair solutions to systemic injustices in Illinois' courts and criminal legal system. So I'm here today in support of the recommendations made in the Illinois Statutory Court Fee Task Force drafted report. The issue of reducing court fines and fees is of particular importance to the Chicago Appleseed because fines and fees perpetuate inequality as opposed to serving justice. Court fines and fees construct a cycle of debt as punishment for people in the court system, disproportionately impacting low-income people and communities of color. For example, a 2017 study by the Fines and Fees Justice Center found that, on average, monetary punishment increases by $34,864 per 100,000 residents for every 1% increase in the Black population. Moreover, collection of these debts are generally inefficient and do not contribute a significant portion of funding towards the court system. The recommendations that the task force have made minimize the burden of legal financial obligations on individuals in Illinois and are undoubtedly a step in the right direction. I would like to emphasize that the Criminal and Traffic Assessment Act, passed in 2019, was a significant step forward for creating a more just Illinois court system. The CTAA has created some clarity in court costs and fees for court staff as well as litigants, and has helped minimize the cost burden on individuals and families. Therefore, we strongly support the elimination of the sunset date of January 1st, 2024. Termination of the provisions in this law would effectively undercut substantial efforts to move the courts towards greater progress and dispensation of equitable justice. While there were many important recommendations in the report, from standardizing procedures for assessment waiver applications to improving data reporting, I would like to highlight two initiatives that are critical to creating a more equitable court system. These initiatives are assessments and fines in juvenile delinquency cases and assessments and fines imposed on defendants sentenced to the Department of Corrections. Chicago Appleseed supports the task force recommendation to abolish assessments and fees in juvenile delinquency cases because youth are rarely independently able to pay these fines and fees, and the burden falls on their families. As fundamentally shown in the proposal of SB 3621, assessing fines and fees for juveniles and their families undermines the rehabilitative emphasis of the Juvenile Court Act of 1987. Furthermore, these fees compound youth hardship by doing nothing to address the root issues that influence youth towards coming into contact with the legal system. Failure to pay these fines and fees create barriers to reentry, such as harming the young person's credit and limiting their eligibility for student loans, rental leases, or car loans. What is proven to be most effective for kids and their families is providing resources to ameliorate the challenges that lead to system involvement. Support for SB 3621 is fully in line with the Illinois Department of Child and Family Services Family First Prevention Act that provides comprehensive services to families to limit youth legal system involvement. As such, we at Chicago Appleseed urge stakeholders to voice support for this act. Similarly, the task force recommendation to create a sliding scale of fees for people who have been sentenced to the Department of Corrections is a point of progress. However, we implore the task force to go further and abolish fees for people sentenced to IDOC, regardless of how long they will be incarcerated, because court costs can act as a significant barrier to reentry from incarceration. Incorporating the findings from this fines and fees task force, the Illinois Criminal Justice Information Authority Research and Analysis Unit displays the collateral consequences of fines and fees imposed on this population, which can amount to individuals foregoing basic needs such as groceries, utilities, rent, among others. Inability to pay fines, considering that the average annual salary for this population amount to $15,000, also led to more than half of the individuals surveyed in the report stating that it negatively impacted their credit. Credit issues can lead to eligibility challenges as far as loans, education, and housing, as previously stated. We strongly encourage a robust push beyond sliding scale methodology towards elimination of fees for IDOC-involved individuals to support reentry into their communities. Research in a variety of systems demonstrates that fines and fees do not create a significant source of revenue for court systems or the counties where they are seated. A key 2019 study from the Brennan Center called fines and fees an inefficient source of government revenue, citing costs of collection, diversion of resources from core responsibilities to collection efforts, and costs of imposing sanctions on those who remain unable to pay. While the prospect of lost revenue is generally unappealing, collecting monetary sanctions has considerable and widely distributed costs for the court system and usually results in spending dollars to collect pennies. The Brennan Center study found that 10 U.S. court jurisdictions spent on average 41 cents for every dollar they collected. Profit from court fees is so low that reducing court fees would not have a significant impact on the court's revenue. So in sum, the report makes significant headway in reducing the amount of court fees and is an important step towards a fully taxpayer-funded court system in Illinois that will eliminate court costs and fees entirely. I want to thank you for your time and work on this report, and thank you for allowing me to speak this morning.
Thank you, Mr. Beck. Does anyone have any questions that they wish to pose to Mr. Beck? Chirag Badlani.
I have a question, I don't know, Mr. Beck, if you're poised to answer this, or maybe Ms. Jimenez, who spoke earlier, but there's been obviously a lot of testimony today on SB 3621, and I just want to understand the ProPublica investigation regarding municipal fines and fees that are imposed. Is the thinking, Ms. Jimenez or others at this hearing who have testified to this issue, that that bill potentially might be amended to include this, or will there be sort of separate legislation that is contemplated? I think I missed that point, or that was raised earlier.
Yeah, no, thank you for raising that. We've been working with the Debt-Free Justice Illinois Coalition, which some of the individuals testifying today on, and really trying to raise this issue. When the language was originally drafted and introduced, this was really before a lot of the investigation, the series came out that was published in April of this year. So really we're working with them to potentially include that within that bill, within Senate Bill 3621, which the number may change as in the new session. But that is our intention, and that has been in our conversations. If that is something that would not be successful, because we're committed to doing this and we're committed to moving this forward, it's possible that it could be introduced as a separate bill, but the hope was to really include this as part of comprehensive juvenile justice reform and really identifying that for the youth, because we're speaking to this specifically to youth, right? We're not speaking to municipal ordinance violations against adults. So that is our intention to do that going forward. And we're hoping to have the support from the task force today on that. So really that's why we were here today. And that's our original intention. But our strategy would be to have this introduced in this legislature, whether it's part of that bill or a separate bill that we're still working on at this point.
Thank you for that clarification.
Thank you. Any other questions for Ms. Jimenez or Mr. Beck? Again, Mr. Beck, I want to thank you both for your testimony today and for the written comments that were submitted by the Chicago Appleseed Center. We appreciate all of that. That wraps up. That's our last scheduled speaker for this morning. And I want to again thank all of our speakers for taking the time to appear this morning and to share their views and their experience with us. You know, the task force collectively has very broad experience, but we have no claim that our knowledge and experience is encyclopedic, and it's invaluable to hear from members of the public who can supplement our experience with their own and share their views with us. So we appreciate your time, and we appreciate your efforts and assistance in the important work of our task force. At this point, the public hearing will be adjourned. The meetings of the task force will reconvene to consider the written and oral testimony and to further act on our draft report. Allison Spanner, do we have a separate Zoom link for our meeting, or are we to stay on this particular Zoom?
We will stay on this Zoom.
Okay. So the public hearing will